and welcome to PubK's 2022 Government Contracts Annual Review. We're thrilled to have more than 3,000 session registrations for this program this year. Over the next 4 afternoons, we will present additional sessions with over 40 presenters and almost 18 hours of content. We hope you'll be able to join us for most, if not all, of these sessions, but a separate registration is required for each session that you want to attend. My name is Alan Schwantgen. I'm the president of the PubK Group and a partner in the law firm Nichols Lew. I'll be your host, facilitator, and moderator for this year's annual review. I hope we'll be able to convene in person next year. The PubK Group consists of 3 newsletters: PubK Law, PubK Compliance, and PubK Cyber. Many of you are already subscribers to one or more of these publications, and we very much appreciate your support. Some of you joining this annual review are not yet subscribers. I hope you'll consider becoming a subscriber. Information is at the website shown on the slide or is available from any of the contacts you have at the PubK Group. This conference would not have been possible without the strong support of our event sponsors, all of whom are listed on these next 2 slides. I encourage you to look at the skills and capabilities these firms have. In lieu of speaker gifts, and on behalf of our sponsors, PubK is making a contribution to the Capital Area Food Bank. With the food crisis facing our communities, including in the military, and here in the Washington, D.C. metropolitan area, I hope you'll also consider making either an individual or an organizational contribution. Since the entire program is being held virtually, all attendees will be in listen-only mode. Your video will remain disabled throughout the session. However, we do welcome your questions. Use the Q&A box at the bottom of your screen. However, with so many attendees, it's probably not possible to answer all of the questions in real time. We are capturing your questions and will endeavor to answer as many as possible after the conclusion of the annual review. All presentation slides, along with the audio, will be available for download from the PubK Group website, probably within a week or so of the conclusion of the annual review. We'll send you information on when this is available for download, how to access it, and for how long the material will be available. In addition, we're applying for continuing legal education in a number of jurisdictions. While we can't guarantee approval, we expect that acceptance within the next few weeks. Again, we'll notify all the attendees when those approvals have been received. And finally, if you're interested in obtaining CLE, please look for our poll question during the presentation. The state boards require us to verify your participation during the event today. The poll is a simple yes/no question. We will track the responses to verify that you viewed the panel. If you do not wish to obtain CLE credit, you can disregard the poll or just answer for fun. Now, I'm thrilled to continue the 7th PubK annual review with our session 2 panel on investigations, disclosures, and suspension and debarment. Our distinguished panel members are Dave Robbins, Jennifer Block, Todd Kenny from Pillsbury, and Fred Levy from Covington and Burling. Fred, over to you.
Thank you, Alan. It's a pleasure to join PubK once again for this panel and to participate with my distinguished colleagues, David and Todd. All of us are joining you virtually from our home offices, and we look forward in the near future to be able to do this live and in person and in the same room together. Can we advance to the next slide, please? So 2021 was a quiet year in the arena of suspension and debarment, at least with regard to case law and regulatory developments. There were no interesting cases dealing with suspension and debarment, at least no cases of note, and no changes in the regulatory scheme. In that regard, while there was talk in the prior administration of developing a new regulatory scheme that would consolidate and make uniform the suspension and debarment regulations under the procurement and non-procurement rules, The government's interest in pushing that effort appears to have faded, at least for now. Next slide. So for purposes of our conversation this year, we're going to focus on trends and issues we've observed concerning present responsibility, mandatory disclosure, and the different suspension and debarment practices that we're witnessing across the various federal agencies. So Todd, first, and David, I'd like to raise the issue of mandatory disclosure. As you know, and as presumably most of the audience knows, at the end of 2008, the mandatory disclosure rule became effective, requiring contractors timely to disclose to the cognizant agency, Office of Inspector General, and contracting officer whenever they become aware of credible evidence of certain criminal conduct, civil false claims, or significant overpayments related to federal government contracts or subcontracts. Under the rule, failure to disclose itself is an independent basis for suspension or debarment, separate and apart from the underlying conduct that gave rise to the disclosure obligation. Now, at the time that the rule was promulgated, as is discussed in the preamble to the rule, DOJ and the FAR Council both noted that the DOJ guidelines for federal prosecution at the time, while not providing amnesty in the event of a disclosure, suggested that the prosecution would be of the individuals and not of the disclosing company. I think that many in the private sector have understood that in the event of such a disclosure, they might possibly have a Civil False Claims Act resolution, maybe a multiplier to some extent on damages, but only in the most egregious circumstances would there be a criminal disposition involving the disclosing company rather than just the individuals. For example, if the principals making the disclosure also were responsible for the misconduct and arguably were using the disclosure to attempt to shelter their misdeeds. However, I relatively recently encountered a situation where a parent discovered wrongdoing on a government contract by individuals at a foreign subsidiary. They thoroughly investigated the situation. They fired the individuals and they disclosed the conduct to the Office of Inspector General and even provided a copy of its report of investigation and fully cooperated with the government. In fact, it was told it was the, quote, gold standard, close quote, of disclosures. The matter was referred to a local U.S. attorney's office, and the AUSA ultimately brought criminal charges against the subsidiary, not against any of the offending individuals. The AUSA did so in total reliance on the company's report of self-disclosure without any further effort to investigate what had incurred, what had happened, other than with regard to damages. And they even brought the case without any knowledge of the civil division of DOJ or even of the civil enforcement attorneys in its own office. Ultimately, the case was resolved with a criminal disposition, but the company was not suspended or debarred because of the extent of its cooperation. So to me, that case was a first. I'm wondering, David, have you encountered any similar situations? And in light of Deputy Attorney General Monaco's statements a couple of months ago about an increased focus on corporate crimes, I'm wondering whether you think this situation is an outlier, or should we expect the consequences of being presently responsible and making disclosures to be criminal prosecution more frequently in the future? David?
Thanks, Fred. It's a good question, and I'm thrilled to be back here again with you and Todd, and it's part of this tremendous annual event. And I share your view. In person is better. I do look forward to that, but we do what we can. But to your question, yes, I have encountered a similar situation a couple of times recently. And for one example, similar to yours, we helped a company submit a substantial disclosure with a lot of backup information, getting tremendous praise from investigative agents, from prosecutors. And at the end of the judicial action, the enforcement action against the individuals, we hear from a different area of DOJ who turn around and brings an action against the company. And such action would have been impossible but for the information disclosed. So I'm not sure 3 or 4 data points make a trend, but it's certainly something we're watching really closely. And I think your follow-up is a good question as well, whether the DAG's recent statements will make this more normal. And look, I've got a couple of thoughts. And first and foremost, I think that DAG's comments about enforcement focused on an agency, the Justice Department, focused on punishment and enforcement, should apply solely to DOJ. It would be a real shame to see that spillover, that punishment focus spill over into suspension debarment. But again, more to the point and more to the focus of your question, contractors really do have to take a hard look at what's going on and understand the increased risk in making disclosures now. And there's a difference, and I'm sure we'll talk about it some more later in the panel, but there's a difference between disclosures that are absolutely required and disclosures where, there's some looseness in the rule, and they may be more in the nature of an abundance of caution disclosure. And that's all part of the risk calculus now.
Yeah, David, that's a good point. And that's one of the things I'm driving at here. If there is indeed, and I think there is, an increased risk of prosecution of contractors that make disclosures, how do they balance that risk with the factors for present responsibility and disclosure? And should companies become more circumspect about what they disclose? In other words, it's often not a black and white question as to whether a matter triggers the level of scienter required for a mandatory disclosure. And should companies, rather than erring in favor of disclosing now, think that realistically such a disclosure could result in a prosecution if the government has a different view than they do of the elements? And if they decide not to disclose, how do they mitigate the risk that the government has a different view, and then a suspension debarment official might look askance at the company for not having disclosed? Todd, do you want to address both of those issues?
Fred, I've got to object as a run-on compound question there, but I'm going to try to decipher that. So, in my experience, I don't know that the DAG statements change things a whole lot in terms of the way I counsel clients. I've always sort of thought that a disclosure creates risks. As David and I used to talk about when we were with the government. The government has several remedies, right? And so I'm always thinking about, what will be the contractual remedy? What will be the civil FCA remedy? What would be the criminal, and what's the debarment remedy? So, when we're making disclosures, certainly we're cautious, right? To get to your question, in what could be triggered. But I think ultimately you want to fulfill the obligations of the rule to avoid a certain adverse action by the SDO's office, which seems to be the most likely of all the remedies. And so if I'm looking at the possible threats that the government has, or the tools, I know that when we make a disclosure to the IG's office, it's shared immediately with the SDO's office. So, and they, from a lead agency assessment. So that's why we always make the disclosures to both the IG and to the SDO's office. And from that point in time, we're trying to mitigate that risk of debarment. So I think, just like you alluded to, we want to think about how do we mitigate the risk, present ourselves as presently responsible, while at the same time being aware that a prosecutor unfamiliar with this system and looking for punishment, as David spoke about, might try to use it against the company. And so for that reason, you have to be mindful of what the remedy the government would be looking for. Has there been financial harm? Is there a way to mitigate that? Is there a way to provide restitution? Is there a way to address the customer's concerns? And I think the more you look at this holistically and try to resolve the aggrieved customer, the SDO, and so forth, I think you can come to a point where you can mitigate those risks. But I think the more prosecutors do what you mentioned, the more there will be instances where contractors choose not to disclose and take on that risk.
Yeah, so I would take a slightly different view. I think that the consequences of a criminal prosecution obviously are significant for a company. And that if there is and that typically, not always, but typically the prosecutors are going to be much more aggressive in finding a violation that rises to that level than would the company or company counsel. And that it's possible to put in place corrective remedial actions and at the same time make a determination that the issue doesn't rise to the level of a mandatory disclosure. And I want to distinguish between a mandatory disclosure that goes to an OIG and working with a customer to resolve an issue and to offer contractual concessions if appropriate. But if by labeling something a mandatory disclosure, it all of a sudden puts an imprimatur on it that there potentially is criminal volitional conduct, I think that does change the way a company will look at this situation. Let me raise a different question, and that is the considerations that a SDO makes for present responsibility determination is different than what a prosecutor looks at for purposes of enforcement. And oftentimes, you know, certainly the level of proof is different. So it could well be, and I've encountered situations that an investigation is ongoing, and it could well be ongoing for some time, but an SDO wants information immediately to determine whether they should continue to do business with the company during the pendency of investigation. And is there a way to both protect your ability to defend the investigation, protect attorney-client privilege, and satisfy the agency's, the SDO's desire for information? You both were in the SDO side of the equation here. David, let me start with you. Do you have any suggestions there?
Sure, and I think we have talked about this in prior years, Fred. I think actually you gave this explanation, which I think sums it up really well, which is you want to give the SDO comfort that no matter what the government says and no matter what we feel about it, right? Because as advocates, we're going to defend our clients and we're going to push back when we think the government's wrong, and we will think the government is wrong in some aspects of what they bring forward. But regardless of any of that, you want to show remediation, even if the government is right about anything and everything. One of the other things I like to do is sort of lean on the old procurement fraud remedies role from the Air Force, which is just making sure information is flowing between justice and the SDO. Oftentimes you'll see SDOs pulling newspaper clippings and asking, what's this all about? Government to government communication is cleaner. It's easier to believe on the government side than contractor to government communication. So the more we can get government to government talking and then overlaying with, no matter what we feel about any of that, here's how we address it all, I think we're in reasonably good shape. The challenge, of course, and maybe you and Todd want to cover it though, is when you can't get that level of communication or you just can't move the government with that sort of advocacy.
Yeah, I'm not quite sure. I'm going to turn that over to Todd, but I'm not sure quite what you mean, David, by the government to government communication. I understand when a matter is resolved, then you can have the government, the prosecutors communicate to an SDO's office about the level of cooperation or what they found. But I'm talking about during the course of an investigation.
No, I understand. And that's where the 302s, which is, FBI vernacular, reports of investigation, are turned over to the fraud remedies coordinators, especially in DOD, on 90-day turns, keeping them abreast of everything that's going on. And that sort of routine, normal communication can be helpful in that it's the government saying what they're focused on. And then we talk in generalities about how to address it. That's all I meant.
Todd, any added views on that?
Yeah, so we've had this situation come up, Fred, you and I, when we work together, as well as since more recently. And it's challenging, right? Because, the contractor might be fighting against an indictment or an active criminal investigation, which could lead to an indictment. And so in that context, you want to preserve your ability to defend that criminal investigation and criminal case while simultaneously putting out the risk of debarment. And so, things that we've done is meeting with SDO offices and letting them know we want to cooperate fully, we want to be transparent, but there are constitutional implications here. And I have found good success with SDOs being nuanced and understanding that they don't want to leverage the SDO apparatus to cause a contractor to have to get out ahead of the criminal case. And so things we've done, as you and I have talked about, are sort of acknowledging that assume the allegations to be true, we have mitigated the risk, we've implemented appropriate remedial measures, and we don't believe that there's any present responsibility concerns stemming from that. And where the misconduct or alleged misconduct goes to individuals, we've done things to show that they're not presenting a risk to the government, perhaps walling them off from the government business, perhaps bringing in a monitor, and perhaps interim administrative agreements. So, that's a lot. But there's ways to deal with it.
Yeah, thanks, Todd. I think that what I have found in this situation is that SDOs have become increasingly reluctant to take an action while an investigation is ongoing, when there is regular engagement between the contractor and the SDO. And if assurances can be provided, but where some SDOs draw the line is when there is an indictment. And when there is an indictment and there is probable cause that SDOs, whether it's for political reasons or because they articulate a concern that there's been a finding that the conduct arises to the level of criminal conduct. And until there's an ultimate disposition and resolution, I don't know exactly what happened. And I can't rely on your representations versus those of the government, that these are the only folks involved and that these are the only events. So it becomes much more difficult to resolve an ongoing potential suspension or proposed debarment in light of indictment than when there is only an ongoing investigation. And to some extent, the ability to do so might depend on how important the contractor is to the government and the government's ability to find other sources, unfortunately. I don't know if you all have different views on that.
Yeah. I've seen it a couple times with indictments, and I've seen a willingness of SDOs to render the contractor eligible with those protections in place and monitoring while the criminal case goes forward. The concerns seem to focus more on the individuals involved and making sure that they're no longer in a position of where the government is at risk. And those where that's where the more complex AA negotiations have gone on, is in walling those individuals off and excluding them for the period of time until the indictment plays out.
But Todd, that's a good segue to the next topic I wanted to discuss with you all, if we could move to the next slide. Oops, back one, I'm sorry. And that's when to engage with suspension and debarment officials, and particularly focused on individuals here. But in the context, not so much of mandatory disclosure, but rather an issue that has come up in my experience in dealing with what I would call voluntary disclosures. And the context is as follows: that there are a number of contractors that do business in both the public and the private sectors. And they they periodically encounter situations that involve wrongdoing by employees where the misconduct has no relationship whatsoever to the company's government contracts or even public sector contracts. And the employees that engaged in the misconduct don't even have any bearing on federal government contracts or public sector contracts at all. But I've now encountered several suspension debarment officials or representatives of those SDOs that take the position that a contractor should disclose that misconduct by their employees, which they saw fit to discipline, whom they saw fit to discipline, even if it doesn't involve government contracts and those employees aren't engaged in government contracts, so that the SDO can take an action against them to make certain that they don't in the future become engaged in government contracts. You know, in that regard, I think it's important to take a look at section FAR 9.4 of the Federal Acquisition Regulation, which are the rules for suspension debarment. And FAR 9.4 defines a contractor to include an individual that can be expected to submit offers for a contract, or who reasonably can be expected to act as an agent or representative of a contractor in its dealings with the government, but not the people that have no nexus to federal government contracts. So, David, what are your thoughts on where to draw the line on what employee misconduct unrelated to a federal contract needs to be disclosed to an SDO?
And we have to look, you cited the exact right language from the FAR, we have to look to that language about who can reasonably be expected to conduct business with the government as a contractor and agent, therefore, right? And there are a few sort of touchstones to use in defining what reasonableness is. I do think what you have just described, Fred, is scope creep on the part of SDOs, and it strikes me as moving towards punishment rather than protection, especially the farther these people are from touching government contracts. And Todd referenced, I think in response to the last question, that as part of AA negotiations, he routinely talks about walling off certain people from government business in its entirety. If that's good enough for the SDOs in that arena, right, they shouldn't be able to have it both ways. Tell us everything, including outside the government contracts business. But if people stay outside the government contracts business, that's acceptable. I do think there's a line there. And I think that reasonably be expected to conduct business is where the rub lies. And I just would hate to see things blur further into punishment if that gets truly expansive in definition.
Yeah, let me play devil's advocate there, David, and take the role of the SDO. So that might be fine if you have that employee under your employment and you control what that employee does or doesn't do. But that's not my concern. My concern is that you've terminated that employee. You've terminated that employee because of misconduct. I want to make sure that employee doesn't now go to work for another company where they can become involved in government contracts or have some responsibility for government contracts. And the only way that I can control that is if you disclose to me the name of that employee so that I can I can take a debarment action. Todd, what's your response?
Well, so this is one that I thought a lot about. Both, when we were both with the Air Force, we did take a lot of actions against executives, engineers, owners, and all of that stuff. And now on the private side, obviously we represent folks in that situation. So it's one that I know very well. And if you look at the definition in 9403, that's the starting place. So the SDO is really limited here. Is the individual currently a contractor employee that's engaging in the government business? Are they having direct interaction with the government customer as an agent or representative? That's the threshold question. If the answer is no, they sometimes will go with this reasonably may be expected to conduct. And that really is limited to former government employees involved in the acquisition function who might have an ability to transfer those skill set over. Absent that, absent someone who has been involved or is on the government side and might be involved, I think it's a stretch to apply it to someone who has no government contracts experience or history and is purely on the commercial side. I think that is overreaching. I don't see that often, but to deal with your hypothetical here, I think this is a situation where I've heard SDOs articulate the concern that perhaps that indicate that one event is indicative of maybe systemic issues at the contractor. And so they want to understand what occurred, how it occurred, and whether it could occur on the government side. And if it could occur on the government side, that's sort of their way into the scenario. And so that's the way I have dealt with it, and the way I think about it. And I believe that answers your question, Fred, but let me know if there's a follow-up.
Yeah, I'm not sure that it does, because I think what I'm hearing from both of us is that from both of you is that the answer is you're not entitled to that information. It doesn't rise to the level of a mandatory disclosure, and we the contractor don't think that there's any likelihood this person is going to engage in future government misconduct. So you're not entitled to it, and I submit it's awful difficult for a contractor that does significant government business to say no to the government. I'm not going to give you that type of information. I mean, and to your point, Todd, that it might reflect on the nature of that employee's ability to do other work. Well, they might be in a business unit in a place where there is no federal government work, period. So I'm just wondering, David, is there a way, assuming that you want to be responsive to your SDO, you even though you don't think you have an obligation to disclose this information, is there a way to define certain types of conduct that you would disclose, even though there wasn't, in your view, an obligation to do so? Or would you just draw the line?
Well, it's not, I mean, it's an excellent
And
question.
obviously it depends on the facts, but it's a general matter.
Well, it also depends on the client, right? Our job is to tell them they're not entitled to this, but it may be easier to give it to them anyway and give them options otherwise. But one thing I like to do, and one thing we saw a lot of when we were with the Air Force, and I'm sure you've provided on behalf of some of your clients as well, Fred, and we all have since, is aggregated information by type of misconduct, by type of employee, whether they touch government contracts, whether they don't, whether they've disciplined, whether they've not. And you can put together a nice little chart to show the responsibility of the company without going that extra mile, if the client is so inclined. But your point is well taken. For repeat players and major government contractors, it's easier to just give the information. And for those who want to send a slightly different message, which is the government gets only what it's entitled to, and or we stand by our employees, they do have arguments to go another way, but they've got to have the fortitude to stick it out if the government presses its case.
Anything further to add on that, Todd? That's a tough line to draw in the sand.
Yeah, I tend not to draw lines in the sand, Fred. I learned from you. I mean, I think, look, what we're trying to do here is we're trying to resolve our client's risk of debarment, and we want to maintain a favorable relationship with that lead agency SDO. It's a rarity to find an unreasonable SDO's office that doesn't sort of understand the issues we're talking about. And so when you do, that's when I think a little bit of education has to go on as to why we're struggling to do this. For example, in California, there's very strict labor and employment laws, and making voluntary disclosures that will cause irreparable harm to an individual is something that a contractor must take into account. Now, if the government customer is demanding it, they can put it in writing and they can ask for it, and then it's a different scenario. So I think we just have to balance the importance of maintaining a good relationship with that SDO versus the collateral, perhaps municipal, state, local level issues and employment privacy related concerns that are at play. But I haven't seen this come up regularly, and in my experience, I think that, if you're making a disclosure just of random commercial misdeeds on the commercial business, that's going too far. If an SDO is demanding it or telling you you're under an AA or you have a close relation, they're saying we want to see it, I think it's one you need to have memorialized. And you got to do your best to then educate the employees during training and in their code of conduct that any acts of misconduct likely will be disclosed to the SDO's office. And then they voluntarily choose to be employed. And I think that's the only way to deal with it.
Yeah, I'll tell you, Todd and David, how I've seen this come up almost almost with regularity, and it's a good way to segue to our next topic. And we have, oh, I'm sorry, not the next slide, just the next topic. And that's the expansive definition of present responsibility and proactive disclosure. So I've seen a number of situations where companies have ended up with misconduct, charges against the company or enforcement actions against the company unrelated to federal government contracting that stemmed from the conduct imputed due to the acts of employees, and the SDOs want to know why you didn't bring it to my attention and who were the employees. So let's continue that discussion. When should a contractor consider the possibility of proactively approaching an SDO on matters unrelated to government contracting, whether it's not only by employees but by the contractor? What type of misconduct should trigger a concern of potential suspension, debarment implications, and an approach to an SDO? And who do you go to if it doesn't involve a government contract? So Todd, you want to tee that one up?
Sure, I'll take a shot at that. So, that is a know it when you see it scenario, Fred. I think it's hard to kind of come out with a clear list. But, I look at it from the perspective of, David and I previously being very aggressive in the SDO field, and what types of things would trigger, from our perspective, a present responsibility concern. And so, honestly, and if anything that can fall under 2C, 9406 2C, right? Anything of so serious or compelling a nature that it affects the present responsibility of the contractor, truthfully puts anything on the table that bears negatively on integrity or ethics. Years ago, I had a client, president of a division, just received information from a government customer, just received information during the performance of a contract that was viewed as non-public information. And notably, there's no law or regulation precluding a contractor employee from receiving this information. It wasn't a bidder proposal information. It wasn't source selection information. It was just, internal government information. He was proposed for debarment and no violations of law, no violation of regulation. So with that perspective, I think you just kind of have to think anything that sort of reflects poorly on a contractor's integrity or ethics is fair game these days. And the closer it is to government contracting, the bigger concern it is. And so I typically have the view that if you handle it appropriately, you investigate it, identify the root cause, implement remedial measures, take appropriate corrective actions and disciplinary actions, and then disclose it, That's the best remedy against a surprise attack from an SDO or a surprise debarment inquiry. And that's just, the simple way we deal with it.
Yeah, sometimes though, it's hard to recognize a situation that could give rise to an action. So for example, I had a situation once where a company was engaged in commercial litigation with a competitor. It had no nexus whatsoever to federal government contracts or any government contracts. During the course of that dispute, the contractor was found to have, or one of its employees to have, spoliated evidence. And that spoliation finding by the court ended up being the basis for a proposed debarment by an agency. So David, same question. I mean, Todd's right, but sometimes you can't really tell. Is spoliation something that would give rise to a potential debarment in typically, or how far should one go in approaching SDOs? Where do you draw the line?
It's a hard question, right? Because that is not the type of thing that at first blush would have caused me to think this is worth talking to an SDO. And ultimately, we're at the mercy of our clients to communicate with us about their issues, whether it's government contracts relating or commercially facing. Ultimately, if they take federal money as an assistance recipient or a contractor, they are potentially fair game given the breadth of the sub-C clause, any other serious and compelling that Todd mentioned. But our job, as I see it, is to just put these things on the radar as potential outcomes. And this gets into our discussion about when it makes sense to proactively approach an SDO outside of a mandatory disclosure context, but just put things on their radar, frame it for them so they don't get the wrong idea with a government only or a competitor driven set of facts and come at you for your ability to receive more federal money.
And David, does staleness enter into it? So the term is present responsibility. How old does conduct that a company discovers or engaged in is too old for going to an SDO?
Well, the joking answer is as old as my older son, but the serious answer is, right, we've sat on both sides. Todd and I have, and Fred, you've been before us and everybody else, all the other agencies, and we've all seen this. The speed of private sector business is very, very different than the speed of a government process. Staleness can be 7, 8, 9 years old, right? Or it can be longer than that in the government timeframe. In private sector, the way things change so very quickly, we might think it's stale after 18 months or 2 years, and we just have to identify that it's the government's timeframe that controls, not ours.
I'd like to switch next slide now. Final topic here that I'd like to touch on with you all, and that's administrative agreements and independent monitors. It's my experience that agencies are increasingly routinely requiring an administrative agreement to resolve any issue of misconduct, no matter how stale or extensive the conduct, or how embedded the contractor's remedial measures have become. And that as part of an administrative agreement, they also demand an independent monitor to oversee and report on implementation of the agreement, for the simple reason that they don't have the internal resources to do so on their own. And then the contractor hears no feedback at all from the agency until an agreement is over. So in light of Deputy Attorney General Monaco's statement that corporations are now going to be subject to independent monitorships more regularly as part of corporate resolutions with DOJ, can we expect to see more monitors and more administrative agreements on the SDO front? So David, you first. Has that been your experience as well?
Certainly agreements are becoming more common and more commonly requested. And whether they're actually doing the government any good, I don't know. I don't know if the papers are read or what the purpose of it is, but it is commonplace. I would like to, though, go back to what I said at the beginning, which is I really think we need to decouple the DAG speech from this because that's punishment focused. And this is more present responsibility focused. Nevertheless, if an agreement is the way we end up getting our clients off the list and contractors get off the list, an agreement is what is going to be welcomed.
So Todd, is it possible in your experience of late to have a an administrative agreement resolving a matter without a monitor? And under what circumstances?
It's unusual, Fred, but I will say that where resources are an issue. So with a very small company or with an executive, sort of a quasi agreement, in both of those scenarios, there could be success without having a monitor. But it does require a lack of resources for the contractor to be able to afford such, right? So that's unusual. I think typically where you're dealing with even a small government contractor that has decent revenues of at least 10, 15 million a year, even that small, you're going to see a monitor. And the way to deal with the costs and the resource issues are just sort of to limit the scope of the monitoring. But typically where there's been a cause and it is recent, they're going to want to monitor. That's been my experience. Now, if you're disputing the allegations, if there's some grayness around whether it occurred, I think that's where you might be able to resolve without an AA, but that wasn't your question. Where an AA is involved these days, I feel like a monitor is sort of almost assumed by the agency.
Thanks, Todd. Look, and before we end here, I know it's time to end. I just want to sound one note of caution. So as in the DOJ announced the formation of its procurement collusion strike force in late 2019, and it is active. And antitrust investigations can become particularly complicated with regard to suspension and debarment considerations for a couple of reasons. First, they often involve bidding on construction infrastructure projects for state and local governments. So contractors have to think not only about federal suspension and debarment, but also local government suspension and debarment. And in addition, many state and local governments have regulations that make misconduct in bidding a public contract a basis for debarment, sometimes even mandatory. And even the fact of an investigation, an event that has to be disclosed in certifications or updated for licenses purposes. So contractors involved in that type of an investigation have to start thinking about their suspension and debarment strategy on a nationwide level in every jurisdiction in which they engage in publicly funded business, and not only focus on federal government contract, which really is a much more difficult task because of the different standards around jurisdictions. And with that, Alan, I see we're out of time. I'm going to turn it back over to you. And you're on mute, Alan.
He just said, Fred, you look great and you did a wonderful job.
That's exactly what I said. That came right after, thank you. And David, I appreciate you adding words in there. You've always been good about filling in the blanks for me, and I appreciate it. Marvelous job as well. Gentlemen, a big thanks to our panel for their outstanding presentation. You covered a lot of great topics, the continuing area of concern to the pub-case subscribers, and I know both the government and the private sector participants learned a lot from your presentation today. Let me again thank all of our event sponsors for their support for today's program as well. And as a reminder, our last panel of the day, oh, by the way, I forgot, apologize. We did have a couple questions come in. Yes, the slides will be made available to you. We'll send them to you afterwards. We'll send you an email when all the slides are put together for the program for this session, as well as for the others. So look for an email from us probably in a week or so. And finally, for those of you interested in CLE, we'll provide some additional information. I know you saw the polling question come up in the middle. If you have any questions, don't hesitate to follow up with us. Thanks and have a great day.